Welcome to today's program titled A Special Multi-Part Series, Guidance on State and Local Paid Sick Leave Laws, Part 11, A Decade of Paid Sick Leave Law Change. At this time, all participants are in a listen-only mode. For those of you who are logged in to the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Josh Seidman. Josh, please go ahead.
Thank you, Kate. Hi, everyone. Good afternoon. Thank you so much for being here for today's presentation, part 11 of our Paid Sick Leave webinar series, looking back over a decade of paid sick leave law change. We have such a great program planned for you today, and making that happen, joining me are my all-star, fantastic friends, colleagues, Tracy Billows, Chelsea Mesa, and Marlon Duro Martinez. As you'll see on the next slide, we have a really jam-packed agenda for you today. We're going to kick things off with a very brief nationwide paid sick leave overview. We'll then turn to a recap of our If Pain, Yes Gain paid sick leave article series, looking back over the last 10 years since that article series began, which was in October of 2013. We'll then go to the meat of today's presentation, that third section, which is parsing the patchwork, the paid sick leave patchwork, lessons learned over the last 10 years. That section is going to be moderated by Marlon and going to involve a roundtable discussion on some very important key sticky points in terms of paid sick leave law compliance for multi-state and nationwide employers. We'll then turn to some updates for what's coming in 2024, in particular looking at places like Illinois, Minnesota, California, and the big activity happening in those jurisdictions. And then finally, we'll wrap up with some thoughts on where paid sick leave laws might be heading in the next 10 years. So a lot of really good content for you all today. Thanks so much for being here. So you'll see on the next slide, let's get things going with our nationwide paid sick leave overview. Next slide, please. So this is a slide that demonstrates the complexity of the existing landscape, how many laws we're talking about, the volatility of the landscape. You can see in that leftmost column, we have total number of mandates around the country. Now this includes paid sick leave laws, paid time off laws, public health emergency leave laws, and the very few straggler remaining COVID-specific paid leave laws. So those all bake into that headcount of 58 total laws that are around the country. Now that number ebbs and flows fairly often. That's been the case since before COVID, but certainly over the last 3 years, that number has changed very regularly as new COVID mandates have popped on the scene. Some have been temporary. Some have taken a more permanent form in terms of public health emergency mandates, like in Colorado and San Francisco. And what we're left with today, again, is that 58 total total laws. Now, you can look at those three columns to the right. We do have a federal mandate impacting certain federal contractors and subcontractors. That's Executive Order 13706. It's been around since 2017, an Obama era mandate. We have 19 states plus Washington, D.C. Again, Illinois with its PTO law, and Minnesota with its paid sick leave law being the two newest additions to this list from earlier this year. Both of those programs go into effect on 1/1/24, and making a big splash just last month was the passage, and then a few weeks ago, earlier this month, the signing into law of a big amendments to California's statewide paid sick leave law. So you'll hear about those later on. And then we look at the municipalities on that rightmost column, more than 24 municipalities with some type of paid sick or PTO law, a number of major cities, several counties, as well as some smaller municipalities. We get to that 58 total headcount because there are several locations that have more than one mandate in place as it stands today. Colorado, being a great example, has both a general paid sick leave law and a public health emergency leave law. Next slide, please. So let's turn to our If Pain, Yes Gain article series and a look back over the last 10 years worth of paid sick leave activity. So if you see on the next slide, so this article series is something that we started back in October of 2013. It was an article written on a local New Jersey paid sick leave ordinance. That ordinance has since been preempted. It's been preempted for almost 5 years now. But we did have, and at the time and throughout the last 10 years, we've published almost 30 total articles on New York and New Jersey paid sick leave activity, given the volatility in those two states. New Jersey used to have 13 local laws. Those were all preempted by the New Jersey state law that went online in late 2018. New York has had tons of activity with its New York City local mandate that's been amended multiple times. The rules were just actually amended last month, and those amended rules went into effect a few days ago. Making up our total 113 parts of this series, right? You can see after New York and New Jersey came Texas. There was a wave of activity in Texas involving 3 localities, Austin, Dallas, and San Antonio. None of those mandates are currently in effect. They've all been tied up in litigation, but tons of articles focused on those 3 big developments. California coming in next. And this, by the way, for California does not include our separate CalPEX blog series. It also contains a ton of good information and articles on California leave-related topics, including paid sick leave. But we've spoken about California 19 times, Illinois coming in with Chicago and Cook County, and now the state's impending PTO law 16 times, and then Washington State with its statewide law and the local laws in Seattle and Tacoma, both of which have been amended multiple times, coming in 5th place with 13 total mentions. We've had almost 20,000 readers in the past 4 years alone of this article series, and we've had more than 33 authors from our SciFAR team over the years contribute to this paid sick leave article series. Next slide, please. The reason we speak about this as far as a 10-year anniversary is because when you look back to part 1 of this article series, which you can see on this slide was in October 2013, focusing on Jersey City, New Jersey's ordinance, there were only 5 total paid sick leave laws in effect around the country. All right, it really wasn't until we got into 2015, 2016, 2017, when places like California and Massachusetts and Oregon and Washington State had their laws come online that the dam really broke and we started to see a wave of paid sick leave activity. So this slide shows you sort of when we hit, and thankfully we've moved away from Roman numerals because we got some feedback from folks, and when we got to part L, which was part 50 in June of 2018, we realized that we were losing some folks, including the authors. So we've moved away from Roman numerals. You can see we are hit part 100 in the middle of last year, and as of just earlier this month, again mentioning California again, we've now hit part 113. We have the next part will be coming out in just the next few days, likely next week, which will be sort of a top 10 list, again, keeping with this 10-year anniversary theme. Next slide, please. And then finally, to wrap up this section, a really unique interactive sort of map here to show you where the If Pain, Yes Gain articles have sort of focused and the imprint that they've had across the country. So the key on the right side shows you whether it's that sort of turquoise greenish color, the state law only focus, right? Articles focusing on only a state law activity. Then you have sort of that orange color if there were both state and local developments that we've written about. The bluish purplish color ordinances only, so local ordinances only that we've written about. And then finally, to differentiate because of this new PTO phase that we're in that started a few years ago with Maine and Nevada, and now Illinois has sort of taken on that mantra. We've also seen West Hollywood, California, and a locality in New Mexico do something similar where there is now paid time off laws in the mix as well. So this map is showing you all of that fun activity, again, to take a look at where we have written articles in this 113 parts of our If Pain Yes Gain series. So with that, I'm going to turn it over to Marlon to kick off the interactive roundtable part of today's webinar.
Thank you, Josh. So you heard about the current patchwork of paid sick leave laws, and there's a lot of lessons from that. And today we're going to look at a number of topics and see the lessons that we've learned in the last 10 years. So next slide, we're going to first talk about using PTO for compliance. So we often hear employers say that they have very generous PTO policies and that they want to use those policies to comply with paid sick leave laws. Tracy, can employers comply with paid sick leave laws by using their PTO policies? And how has your answer changed in the last 10 years?
Thank you, Marlon. So yes, employers can use PTO to comply with paid sick leave laws, but I can tell you my answer to that question has dramatically changed in the last 10 years. In the beginning, when these paid sick leave laws were first coming out, a lot of the laws focused on having programs that were as generous or conditions similar to the law, et cetera, et cetera. However, as these paid sick leave laws have continued to come into effect and the numbers increase, the differences in what is provided and what is required under the laws has dramatically increased. And in many cases now, we spend a lot of time assessing whether PTO does in fact make sense for employers based on the jurisdictions they're in, the headcount in those jurisdictions, the other competing state wage payment and collection laws that may be out there governing PTO that also come into effect. And it's not quite so automatic to say, yes, go ahead, you should just use your PTO policy. And we have a couple of revisions and modifications and you're good to go. It's a much more extensive process today, and it has been building to that much more extensive process for quite some time. And I don't think it's going to change. We've seen many employers now start to split their PTO policies again back to PTO and being part vacation, part sick. And having two separate policies instead of an overall paid time off policy. And I think we're going to continue to see that. Look, we're not unmindful of the fact that PTO is in many ways administratively easier to administer in concept because it's one bank, someone just taking paid time off. But given the complexity of the paid sick leave laws and the requirements that come into play, it's just not the easy answer anymore.
Thanks so much, Tracy. Chelsea, what are your thoughts on the use of PTO for PSL compliance, especially in dealing with California as well?
Yeah, California doesn't do us any favors. I mean, it is one of the states where, because we've got laws on vacation and laws on sick time, it's one of those situations where you have to have that interplay, which does add a layer of complexity, like Tracy was touching on. I do remember when the California sick pay law first went into effect, everybody was jumping on the bandwagon of, oh, well, I've got PTO, or I'll just convert my vacation into PTO and it'll work out great. And I think that was an immediate reaction until we saw some fairly strange guidance from the DLSC about how the California kin care law, the California sick time laws were going to interplay, and really trying to get a gauge of how much of that time, if you're going to be really generous, is going to be considered protected time. And so I think because of that uncertainty, these types of structures just don't tend to work well for certain populations, especially if you've got a lot of, a lot of excessive use when it comes to PTO policies and a desire to rein that in. So it does make it a little bit more challenging. And, like Tracy touched on, because of things like wage payment laws and differences between how maybe vacation can be paid and sick time can be paid, it just doesn't lend itself nicely to an easy solution. And I think that's become much more apparent over the last, especially the last decade for sure. So I think similar to Tracy's field, but even more so in California, that these types of policies may seem like something that is appealing and employees tend to really like them, but there's a reason they really like them. It's because it might end up being harder for employers to manage.
He's right. Picture taking all of the provisions from the state wage payment laws and vacation laws and the paid sick leave laws and lumping them into one big policy now, because that's what today's reality is. You've got to combine all of those and comply with all of those if you're going to go down the PTO route. Again, we're not saying impossible, but it's just not the simple solution that perhaps we would have thought 10 years ago.
Thank you both. So speaking of lumping everything into one policy, we're going to move on to our next topic. So some employers want to comply with PSL laws by having a separate policy for each location, but others want to just comply by using one nationwide, one-size-fits-all policy. Josh, can employers comply with PSL laws with nationwide one-size-fits-all policies? And how has your answer to this question changed over the last 10 years?
Yeah, thanks, Marlon. Really, really great points. And this is a topic, the one size fits all. It's the golden standard, right? It is the goal for multi-state nationwide employers because it sounds super simple when you just sort of say it out loud, right? I'm going to cut through all the technical messiness of these laws and all their conditions and requirements. I'm just going to go with the lowest common denominator, the most generous aspect of each of these conditions for workers across the whole country. And then I'll be good, right? And good to go. And this concept has been around since the paid sick leave law world really kicked off, again, 2015, 2016, 2017. But even then, it's been more of a pipe dream than a reality, right? Not quite sort of a fake news, but just a really steep burden for companies that want to go this route. And here's why. Even with those original first, 5, 10, 15 paid sick leave laws, they're inconsistent across law to law. And they have some really big differences that make one-size-fits-all policies unattractive for employers. They result in big windfalls to employees. They result in absenteeism issues and greater costs for the company. And again, even though it sounds as a theory nice out loud, because of those inconsistencies and their differences, it creates this big challenge for companies to navigate that type of policy. And here are some details to put this into perspective. Some of the laws, right, across the country say you cannot have any cap on how much time workers accrue in a given year. Places like Washington State and New Mexico, for example, fall into that group. Then there are another group of laws that say there can be no cap on how much sick leave you can use in a year. Places like a bunch of the Bay Area laws in California and Washington State, and the new Minnesota law that's coming online in a few months. Then there are some laws that say you can't put a cap on year-end rollover for unused time. So what it boils down to is if you truly want a one-size-fits-all nationwide policy, it has to have no cap on accrual, no cap on usage, no cap on year-end rollover, which creates the feel, because it sounds a lot like it, like unlimited PTO, unlimited paid sick leave, excuse me. So if that's the route that the company wants to go, now there are some anchors that you can put in place, some guardrails and limitations, but in essence, that's what it boils down to. In addition to complying with all the reasons for use, all the minimum increment standards, documentation, notice, rate of pay, and all of that.
Thank you, Josh. Chelsea,
Sure.
what do you advise employers who want to implement a nationwide one-size-fits-all policy?
Yeah, I just to dovetail to what Josh was saying, on top of everything that he mentioned, there's also the amazingly different and inconsistent written policy requirements that you actually have to put on paper in order to do this. The question that I commonly will ask employers when they're looking at this is to compare the cost of being really, really generous with the cost of administering multi-policies behind the scenes. And I've been having that conversation probably more and more over the last couple of years of the last decade than I was at the beginning. I think at the beginning, especially before what I'm calling the great scatter, when everybody's employees went and moved all over the place, it was really, let's just manage one or two places and this won't be so bad. We can do a one size fits all because we're not really dealing with that many different laws. But as that great scatter happened and we were dealing with more and more and really, oh, can't you give me a policy that will work, everywhere? And aside from not having a crystal ball and not knowing what's going to happen over the next 10 years, I do try to explain the complications, like Josh mentioned. It's not impossible, certainly not. And usually where we settle is something that I call a one size fits most, which is drafted as a best case scenario with a bunch of footnotes. And so, yeah, there's still going to be some administration behind the scenes. There's still going to be a few things that we have to tackle that are different. Like Josh said, the difference between caps on accrual, caps on use, caps on carryover. And in those three major categories, you can pretty much tackle everything. And when I do that, I do then ask, are you comfortable being this generous in all places versus the cost it will take from behind the scenes to navigate through X number of separate policies? And so that allows, I think, companies to wrap their minds around what they're talking about. Is it being generous to your employees that is more concerning from a cost perspective? Or is it that I'm going to have to hire 17 new people behind the scenes to administer the different policies? And that's a decision that I think a lot of employers just have to make for themselves. But certainly something that we're having those conversations about that so much more often now than we did at the beginning, when we were really looking not really at one size fits all as much as one size fits the 5 jurisdictions where my employees are working.
Yeah, absolutely, Chelsea. And I'll say I love the great statter. That's a cool term. I'm going to be using that one as well. I think that's such an important point, because what a lot of companies will come down to now is they'll say one size fits all, maybe not the windfall, the route that I want to go, but one size fits most, right? And looking at where we have these outlier pockets because of our workforce and our headcount, and understanding that even if we only have a handful of folks in one location or 2 locations, maybe the law is technically triggered, but then we do a risk analysis. How much do we want to let that minority of workers dictate our overall policy setup?
Thank you both. And this leads us nicely into the next topic. So for employers who do want to just be very generous, they ask if having an unlimited PTO policy complies with PSL laws. So Chelsea, I'm going to go back to you on this one. Can employers comply with PSL laws by using an unlimited policy? And how has your answer changed over the last 10 years?
Yeah, it's a great question, and I will give you my favorite legal answer, the it depends answer. And I think that the concept of unlimited PTO is subject to a lot of misconception, and there's a lot of misunderstanding about what we're doing, because I don't think there's really anybody anywhere in any company that truly intends to provide employees with a benefit that is unlimited. If you do that, then who comes to work? I wouldn't. And so the idea would be trying to actually figure out what you mean by unlimited PTO, what you're trying to accomplish with unlimited PTO. And I certainly think that there are some jurisdictions, maybe where the commitment to the minutia is not as important, where a routine or flexible time off policy could be sufficient to meet the compliance standards of some of those jurisdictions. I think where things get really tricky are places like California, where even a decade ago, these kind of routine or flexible time off policies were starting to take hold, and people were really starting to implement them. But there was a lot of unknown even at that time as to whether they were going to be deemed proper by the state agencies. And the first guidance we got on this, as many of y'all know, was in April of 2020, when, believe it or not, we had a few other things that were distracting us, but a case that didn't go so far as to hold that these types of policies were improper, but really that if you wanted to do them, you had a lot of things you had to do behind the scenes. You needed a lot of things in your policies, and didn't really touch on them from a sick leave compliance perspective, only really focused on them in terms of vacation. And that made it a little bit more challenging. But from a sick time compliance perspective, there are so many administrative requirements for these laws that we know we also have to abide by. Just thinking about California and having to put the amount of sick time available for use on the pay stub. And how do you do that? The law says you can just write unlimited, but as we know, we're not really talking about unlimited PTO. We're talking about more of a routine or flexible system. And so there's just a lot that has to be taken into consideration. And I think as we've marched forward, we're kind of recognizing the administrative challenges that go with this. And so we tend not to recommend trying to use your unlimited PTO, especially in California, not to use these types of policies to cover your compliance, because we don't really have a lot of faith that you're going to get there at the end of the day.
Thank you, Chelsea. Tracy, how about you? What has your experience been with unlimited PTO considerations?
Yes, first of all, I'd like to put an X through the word unlimited. We get these all the time, and we do get creative with all of you in coming up with names for them, but never, ever, ever use the term unlimited in your official policy. The fact that you got us to put this on a slide is pretty remarkable considering how often we all take our pen to it and change it. And that's not changed in 10 years. I will tell you, I think the appreciation for the complexity of these policies and what they mean in the paid sick leave world has really transcended even beyond California. Look, don't get me wrong, California has its very particular requirements, the McPherson decision, all of those things. This is why we have Chelsea, so that I don't have to worry about any of those things. Having said that, though, California is not the only tricky spot. All employers who are covered by the Family and Medical Leave Act. Let me give you a scenario here that's going to make this very, very complicated. You're using unlimited PTO to comply with paid sick leave. You say that individuals, to the extent allowed by law, must substitute paid sick leave for any unpaid FMLA. Guess what? FMLA is 12 weeks. You have an unlimited PTO policy. What does that mean for the individual substituting their unlimited PTO as sick time, which is what you're using it for compliance purposes, for unpaid FMLA, such as to take care of a family member where there's not a paid family member leave law, or for some other reason like qualified exigency where there's not a paid leave law that provides that. These are the complications with relying on unlimited PTO for paid sick leave compliance, because not only are you dealing with the compliance considerations of the paid sick leave laws, but by extension, how those paid sick leave laws intersect with your other policies, whether it be the Family Medical Leave Act, CFRA, other state unpaid FML laws that are out there, as well as paid family leave laws that are out there, and the coordination of benefits across all these different ways that individuals can ultimately apply for paid leave benefits. My recommendations in this regard for all jurisdictions, not just California, is that you carve out from your unlimited PTO policy any other time off benefit that the company provides or any other leave benefit that the company provides. This really needs to be for things like routine time off that might not rise to the level of a covered paid sick leave reason. Maybe it does, maybe it doesn't, maybe you're in such a jurisdiction, but also making sure that you are not using this for FMLA absences, you're not using this for family leave, you're not using this for a variety of other considerations. Even things like bereavement leave are complicated in the unlimited PTO. So many of the paid sick leave laws now cover bereavement leave as a reason for use. And so companies who have had policies that say 3 or 5 days as the benefit being offered, this policy is a game changer if someone reads your policy and it's not correctly worded to indicate that, no, you got to go to the bereavement leave policy to figure out how much time off you're going to get. You can't elect this policy to take off that unlimited time. And these are just some of the examples. I mean, even Chelsea and I used to debate, and I can remember some old drafts, Chelsea, where we would put in these policies, you can use up to 2 weeks for like STD qualifying periods and things like that. Even that's dangerous because the case law has come out and said any quantifiable term that you put in these policies is going to be used against you as a potential payout for the minimum payout that needs to be done in those states that require payout upon termination. So I realize I just said an awful lot. These are things that have just been evolving over the last decade in terms of our advice, et cetera. But do know that this is not, just like PTO generally is not the end all be all solution, unlimited PTO is most definitely not the end all be all solution. And be very wary of the additional problems it can create for employers in a whole host of other areas that you probably would not even contemplate as you're first instituting such a policy.
Thank you, Tracy. So the next topic that we get a lot of questions about is front loading versus accrual and unused time at year end. So Tracy, I'm going to go back to you on this one. What are the pros and cons of front loading versus accrual, and what impact do these methods have on carryover requirements? Also, has your answer to this question changed over the last 10 years?
Thank you. So this is probably not one that I've dramatically changed on because it's always depended on how the law was written. And so this one for me and the advice that I have provided over the years in conjunction with you, Marlon, and Josh and Chelsea has really depended on what jurisdictions we're talking about and what their laws say. It also goes back to what Chelsea mentioned as well, which is sort of what are your goals as the employer in terms of your program, right? Are you looking for administrative ease? Are you looking for cost control? Are you looking to prevent abuse? Are you looking to address excessive absenteeism, right, in certain places? All of that's going to drive what makes the most sense for you in terms of front loading versus accrual. But understand, generally speaking, this is really going to be driven by the law and your business objectives. So for example, where there is a law that says all I have to do is front load 40 hours and then I don't have to carry over 80 or carry over 40 or some other amount or track anything of that sort in terms of accrual rates by hour or things like that. If I'm the client who really wants the administrative ease and I don't want all the programming problems with my payroll and HRIS systems, I'm going that route because that makes the most sense for my business objectives. Now, it may mean that all of my workforce takes off January because I've now given them 40 hours in January. Understand that is the sort of consequence, but it also means for the next 11 months, I don't have to worry about this, right? Others who are very, very concerned and have high rates of turnover in their industries, right? The accrual method is usually one that is going to be preferred there because this way individuals are not getting this huge bank of time working for you for 1 month, quitting and have already taken off 1 week of sick leave, right? They're just accruing pursuant to the legal requirements. And ultimately, especially for new hires, as you know, if you institute the waiting periods that are allowed under most of these laws, not all, but most, you also can prohibit that abuse and misuse of the sick time early on in the employment. And so for those employers, when we're talking through their business objectives and needs, that's what we're talking about from an accrual standpoint. But at the end of the day, the front loading is really what's going to get you to, in most cases, not all, because some you can't front load and get rid of the carryover, but most, you can front load the time and get rid of your carryover obligation. And you're just starting each year fresh and anew. And it makes it from a record keeping and usage far, far more easier to handle. Additionally, putting aside the PTO laws that Josh mentioned at the outset, which are a little bit different than the pure paid sick leave laws that we have been encountering, you don't have to pay out paid sick leave upon termination. So it's another consideration in the front loading accrual model, because at the end of the day, unlike vacation or PTO, if you front load it and you're in a state like California or Illinois or Massachusetts, or you're going to have to pay that out upon termination, regardless of how long they worked in the given year, you're not going to have to do that in the paid sick leave world. So advice has definitely not changed here, Marlon. It's become more nuanced because all these laws, unfortunately, all have these little, slightly different provisions or ways of doing this, including point in time accrual caps, which I won't even get into. I'll let Josh deal with that because those still drive me crazy. But putting all that aside, that's kind of where I stand on this issue.
Thank you, Tracy. And with that, Josh, what are your thoughts?
Yeah, I would echo all of Tracy's comments. I think a lot of this comes down to company goals. If we have a lot of turnover, if we have a big part-time or non-full-time population, right? If workers tend to use a lot of time at the start of the year, then accrual makes sense. But for administrative ease and attractiveness to workers, a lot of workers think front loading is a more attractive benefit. So there's an employee relations component that comes into play. You want to get rid of accrual tracking and year-end rollover in as many places as the laws allow. and that administrative ease, then front loading is the way to go. But you need to be comfortable with the windfall that it brings. So I think those considerations are all spot on. And it comes down to some companies where they might front load for, say, their exempt population or their full-time population, but then accrue for their non-exempt or their part-time population. That certainly is a practice that we've seen companies go with. The only complexity there that sort of comes up is, one, programming both accrual and front loading in your system, and then dealing with workers as they transition between full-time and part-time or exempt and non-exempt.
Thank you, Josh. So going on to the next topic, we're going to talk about enforcement of paid sick leave laws. So I know that all four of us have represented employers in connection with investigations by various enforcement agencies in connection with the employer's paid sick leave practices. So Josh, I'm going to go back to you with this one. What have you been seeing lately in terms of paid sick leave enforcement? And how is what you're seeing now different from what you have seen in the last 5 or 10 years?
Yeah, thanks, Marlon. It's different now than it was 5, 6, 7, 8 years ago, 10 years ago. Enforcement is picking up, and it took some time, I think, for these paid sick leave jurisdictions, one, to sort of get enough administrative support and bandwidth to really enforce these laws, or for the plaintiffs bar to kind of wake up to their existence and potential gaps and shortcomings that companies might have with their compliance setup. So 5, 6, 7, 8, 9 years ago, enforcement was more theoretical, still pockets of enforcement, but more theoretical than it is today. But that isn't the case anymore. Enforcement is on the rise, and this includes enforcement by both state and local agencies, as well as in certain states that allow for a private right of action by the plaintiffs bar in those states. And companies, when you're faced with one of these administrative audits, it very quickly takes on the feel of this quasi-class action. The agencies expect data and information about the entire sort of breadth of the workforce in that jurisdiction. So sort of leapfrogging all the pleadings portions of litigation and going right to what feels like class-wide discovery. And that takes a big burden on companies before you even get to the potential penalties and administrative fines that could come if you're found to have not been in compliance. There are some places, some jurisdictions that are more active than others, more proactive with their enforcement. New York City and Seattle and Massachusetts and Arizona. Certainly the plaintiffs bar in California is picking up steam with these issues. San Diego and Los Angeles and their localities. So we're seeing quite a bit of enforcement scattered throughout the country. And what makes it even more impactful for companies is that a number of these laws come with extreme penalties. We're talking about per day, per week, per worker violations, right? Fines that can be stacked on top of actual restitution and back wages that could be owed to employees.
Thank you, Josh. Tracy, I'm interested to know what you have seen in Illinois and beyond in terms of enforcement.
Yes, so we have the new Illinois PTO law coming into effect pretty soon, which I know you are going to be sharing with all of our wonderful participants momentarily. But we have had the Chicago and Cook County paid sick leave ordinances in effect for some time now. And we have seen an uptick in enforcement in those jurisdictions, more so in Cook County than Chicago, but in both. And we are seeing a number of things happening. There is a lot of confusion at the agency level when employers are using PTO policies to comply. And the agencies are really trying to parse out, have you in fact complied with all of the provisions related to paid sick leave in your PTO policy? So hearkening back to our comments about some of the other compliance considerations, they pick those policies apart in Cook County and Chicago to understand. So that's been one trend I've seen. Another I have seen is the issue, and this is not unique to Chicago and Cook County, it's actually certainly something that is in other jurisdictions, is how to handle union employees covered by a collective bargaining agreement. There were exemptions put into the Chicago and Cook County laws that allowed people to not have to comply for a period of time, whether it was until the next contract, et cetera. And there's various other paid sick leave laws that have these provisions as well. These get very, very tricky to demonstrate compliance because you have to literally go through the bargaining history to show when did the issue become ripe for enforcement or enactment by the employer versus when was perhaps this grace period or exemption period or waiver period in effect. So it can get super, super complicated. And I think it's going to continue to get more complicated as more laws allow for this type of arrangement.
Thank you, Tracy. Speaking of complicated topics, next slide, please. With COVID, we saw a lot of workplaces shift from work to working from home. Since then, some employers have stayed fully remote, while other employers have brought back their employees in the workplace for 1 or more days. So having fully and partly remote employees complicates compliance with paid sick leave because employers may be triggering additional laws that they did not previously trigger. Chelsea, what has been your experience with helping employers navigate paid sick leave compliance for fully or partly remote workers, and how has your advice changed in recent years?
Yeah, it's interesting. I think specifically because of COVID and what I have coined as the great scatter, we did see such an increase in the volume of remote workers over the last couple of years. Back early in the day, before that, it was the occasional remote worker. There was a lot of employers either not fully recognizing that they might be subject to laws where those employees were performing work, or deciding that it wasn't something that they weren't willing to take some risk on by just having a sick time policy that covered where they had the vast majority of their workers. I think that has changed quite a bit. I think now that we've got workers in so many different places at the same time, we really do encourage our clients and the employers that we work with to take a look at where their employees are actually performing work. And I think anytime I work on a handbook, anytime I work on a policy, it is probably the first question that I ask of the clients that I'm working with, because knowing where they perform work, knowing how much they're performing work, these laws change or are different from jurisdiction to jurisdiction about how much work in a particular area will mean that you are covered by that particular law. And so if you've got a hybrid employee who's performing some work in one place and another, it may be that they are in fact covered by more than one law. That doesn't mean that we have to provide them more than one sick time bucket, but we do have to at least have the information so that we can make a more educated recommendation around how that employer should handle sick time for their remote population. And sometimes that means having a different policy for their remote workers than they do for the employees that work in their facilities. So it's certainly something that we're seeing a lot more questions on. It does dovetail nicely into what we were talking about before around that one size fits all solution, or a PTO type of solution, because these are all things that I see a lot of our employers looking at more and more with the remote population expanding as it has over the last several years, really having to focus on where they are performing the work. Because if you read the laws very closely, that's really what the laws focus on, where the employee is actually performing their work and whether they perform enough work in that jurisdiction to trigger that law, even if that's not where the headquarters of the organization are.
Thank you, Chelsea. So moving on to the next topic, payment of paid sick leave. This topic is so complicated given that paid sick leave laws have all different kinds of standards when it comes to this. And then we get wage and hour laws involved as well. So Josh, what has been your experience with helping employers navigate payment of paid sick leave to avoid both paid sick leave law and wage and hour compliance issues? And how has your advice changed in recent years?
Yeah, thanks, Marlon. Completely agree. I know this is one of our mutually shared favorite topics. It is, I think, payment of sick time falls into this category of sort of behind the scenes paid sick leave compliance obligations, along with things like notice and posting and record keeping and balance notification. It is potentially the most impactful of any of the paid sick leave substantive requirements, that being payment of sick time, because of the potential for class-wide exposure to companies to the extent they are misstepping on this point. And as anyone who's sort of dialed in, who's dealt with wage and hour lawsuits and class and collective actions can sort of attest to, they're no fun. There's a lot of risk and a lot of potential liability, right, if there's missteps. So payment of sick time, I think, is a topic that has gained a lot of steam, a lot of traction. And the reason being, especially for groups like hourly employees, non-exempt workers, especially, you know, and including the salaried non-exempt group, you know, one of my least favorite designations, commissioned workers, employees who are paid a variable rate, multiple rates, you know, in a given week. Because the sick leave laws, as has been the case with many of the topics we've spoken about, have varying standards on the proper rate of pay for payment of sick time. When we're thinking about hourly workers, some laws and frankly, a lot of the laws are drafted poorly, which leads to the confusion and the ambiguity in this space. But when you look at the laws, they can be broken often into one of three categories, and some of them have subcategories, which make this even more fun. But they are often payment to the hourly employees based on their normal base hourly wage, or paying them at the rate in effect, which boils down to most often what they would have earned had they worked that shift or what they normally earn during hours worked, or paying them at their regular rate of pay, basically the weighted average as called for overtime purposes under the FLSA. And that then requires companies to sort of sit down, to conduct what is essentially a pay audit. So that's where a lot of the practice has changed in recent years. Companies are starting to take this topic much more seriously. They're diving into their pay practices and figuring out what types of compensation might need to be factored into their payment of sick time calculations, what might be owed to workers based on the letter of the law in those jurisdictions, or at least the more conservative reading if the law is worded in a poor way. And on the other side of the coin, the plaintiff's bar is also waking up to this being a potential low-hanging fruit with a big reward if they can catch a company that's been misstepping. So a lot of moving pieces within payment of sick time is something companies should really be paying attention to.
The next topic also brings in a different area of the law, labor law. Sometimes we hear from employers, they say, well, we don't need to worry about this section of employees because they're union, they're covered by the CBA, we don't need to worry about paid sick leave. Tracy, is that right?
No, it is not. Make sure you talk to your traditional labor lawyer because you are going to be negotiating certain things sooner rather than later now. I don't mean to steal Chelsea's thunder, but she's about to tell you about the California amendment that is going to change the CBA exemption in California. That's going to require employers to ultimately ensure that whatever's in the collective bargaining agreement meets certain minimum requirements, or guess what? Gonna have to enact something or talk to your union about renegotiating. And I think you're going to continue to see that come up more and more in some of the other laws. So don't just assume you have an automatic exemption. Also, don't assume that these exemptions are permanent. Many of the laws say you have to do it with each collective bargaining agreement. Make sure you're talking to your traditional labor law lawyer as well as your PSLL lawyer to know what exactly you need to put in that CBA so you are not caught off guard by any claims.
Thank you, Tracy. So moving on to the next topic. A lot of times in advising clients and throughout this presentation, we've heard you can do this in a lot of locations, but not in California. So Chelsea, tell us some more about that.
Yeah, I get to give all the good news, don't I? You know, it's funny. I think California still holds the title of having the most local ordinances within the state. I think that's still right. And over the last several years, you know, we started with San Francisco, then we expanded to Oakland. Even before the California law was passed, we've seen it kind of spread around the state in a lot of jurisdictions that you would expect, as well as some maybe that you would not. And then the newest trend in California is we've got, you know, West Hollywood does have its PTO law. And so we certainly are expecting to see more in that space over the next several years. I think what we started out with was trying to figure out how we would reconcile when you're an employer who's got folks within a city that is a local, you know, has a local ordinance as compared to the state. Is the state going to, you know, preempt something and ultimately deciding that it does not? And so having to give the best of both. And sometimes that's at a local level and sometimes it's at a state level. So it's drafting these policies that really do carry forward some of those points to make sure that an employer who is working and is subject to multiple of these laws is actually getting what they're supposed to from all of the laws that they are subject to. And so I think it's not uniquely only California anymore. I know there are local ordinances that are still in play across the country in some jurisdictions that also have a state law. But California certainly continues to lead the charge. I wouldn't be surprised if we see additional developments over the next few years trending towards what West Hollywood is doing, that I think a lot of employers are kind of recognizing that there might be a need to even go back to the PTO model if there are more laws on PTO like the West Hollywood law. So that's something that I think we can I would say look forward to, while I make a weird face, over the next couple of years. But certainly a developing area. California continues to want to tell all the other states to hold its beer.
So Chelsea, in 10 years, you're going to advise go ahead and use PTO laws, PTO policies again. Is that what are you making a prediction for our next 10-year program?
I am predicting that we will probably see additional reasons why that might make more sense, but not today. Not today.
Thank you, Chelsea. So from that concludes the roundtable, but we want to hear about the California updates that Tracy mentioned. So if we could go to the next slide, please.
And
One more.
skip one more. Yeah, there we go. And I'll just touch on these from a very high level. I know Tracy touched on something that's a pretty nuanced aspect with respect to the CBAs, and we'll have an opportunity, I think, to talk about that more in some of the other webinars that we're going to be doing in the future. But I do want to hit the very high level points is in that as of January 1, 2024, California PSL, which shockingly happened to be kind of below the average standard up until now, it was at 3 days or 24 hours. Now it's going to be 5 days or 40 hours. And this is going to impact your policy regardless of whether you were using a grant or you were using accrual. If you were using a grant, obviously your grant has to increase. If you're using an accrual, you may recall that there was a accrual cap at 48 hours, a point in time cap at 48 hours, even though the annual use was lower at 24. That is increasing. So if you are accruing, even though you are allowed to cap annual use at 40, you do have to go all the way up to 80 with respect to your point in time cap. So that is a pretty significant increase, and very important, because as of this year, other than in San Diego, who already had an accrual cap at 80, all of these other places that had an accrual cap at 72, you're going to need to increase that to 80 as well. Because again, as I mentioned, California is a place where you got to give the better benefit. And in this case, the state benefit is going to be more generous than the 72 hours that we were already dealing with. And like I said, we'll touch on some more of the specifics around California and some of the other webinars we're doing, but I wanted to give the kind of immediate bad news with respect to the increase in our session today.
Thank you, Chelsea. So going on to the next slide, another law coming into effect January 1st, 2024 is the Illinois Paid Leave for All Workers Act. So one important thing to keep in mind is that it's very broad. It applies to virtually all employees and all employers. There is a carve-out, however, for employers covered by the existing municipal paid leave mandates, like the Chicago and Cook County mandates. If you're in a jurisdiction that had opted out of the Cook County paid leave mandates, however, you will be covered under the Illinois statewide law. In terms of the amount of leave, the law allows employees to use 40 hours of leave per year for any reason whatsoever, and you cannot require any documentation. So not, there's bad news coming out of Illinois as well, not just California today. However, the good news is that under this law, there's no payment upon termination. However, if you're using a paid time off or other type of law to comply with this law, then you will have to follow traditional Illinois law. Like Chelsea said, we'll be talking more about Illinois in an upcoming webinar. On the next slide, this completes the trio of the 3 laws coming into effect on January 1st, 2024. We have Minnesota. This law has no impact on preemption. So if you are in Bloomington, Minneapolis, St. Paul, or Duluth, you will still have to comply with those laws as well. The law is very generous to employees. It provides leave at 1 hour for every 30 hours worked with a 48-hour annual accrual cap and an 80-hour point-in-time cap. There is no carryover cap, and there is no usage cap or a waiting period. So it's very employee friendly and has very broad reasons for use and broad definitions of family member. It also comes with a number of requirements, including balance notification requirements, as well as notice and posting requirements, and a handbook notice requirement. And to learn more about handbook updates, join tomorrow's webinar where Chelsea will be discussing a lot of handbook updates there. Next slide, please. So finally, just some other notable recent paid sick leave activity that's been happening. Colorado and Connecticut have both amended the covered reasons for use. Oregon has amended the covered family member definition. And in New York City, there's been a lot of amendments that went into effect on October 15th because the city released amended rules. The rules impact a number of important topics, so make sure that your New York City policies are updated for that. And with that, before I turn it over to Josh, I'm going to give you the CLE number for today. The CLE number is SS as in Seyfarth Shaw 2145, SS as in Seyfarth Shaw 2145. And with that, I'll turn it over to Josh.
Great, thanks, Marlon. Last substantive topic for today, sort of 10 years worth of paid sick leave that we've covered. What's going to happen in the next 10 years? Let's go to the next slide. We'll look into our crystal ball and give you some high-level thoughts. So number one, for starters, right, the patchwork, unless there is a federal law that preempts the locality and state paid sick leave laws, which does not seem like it's on the table at the moment, despite many folks in the employer community crossing their fingers and their toes and wishing that would happen, doesn't seem like that's on the table at present. So short of something like that coming down the pipe in over the next several years, this patchwork will continue to expand. It's certainly been that way over the last decade, certainly the last 7-8 years for sure. What are some of the top prospects that could be added to this list? You can see them here. Nebraska, they have actually a campaign right now ongoing, collecting quite a bit of money over the last several months to try to get paid sick leave up and running in that state. Hawaii, Virginia. Virginia comes to mind in particular because while it has a statewide law today, it is limited to certain home health care workers. Having Virginia expand beyond home health care workers would be a big deal. Delaware, which just enacted a paid family leave law in recent years, could see it sort of take a swing at paid sick leave as well. And then New Hampshire and also Pennsylvania comes to mind. Pennsylvania in particular, because it has 3 local paid sick leave laws. So maybe the state would take a page out of California or Washington or New York's book and add a statewide law as well. Now, that being said, we're running out of states that are, from a political perspective, sort of blue or purple states, right? And that tends to be where we see the most sort of employee-friendly employment law activity like paid sick leave. So what does that sort of mean? Well, it could mean, one, that we'll have in that third big bolded bullet point, some more tinkering around the edges, or big swings and big amendments. So that can mean adding reasons for use, like we heard Marlon talk about for Colorado and Connecticut, or big amendments like we just saw in California. Other states could look to up their reasons for use or up their amounts of leave. They could also have states with existing sick leave laws look to convert those to PTO laws. There's actually a proposal right now in Chicago that would convert their paid sick leave ordinance. It's been around since mid-2017 into a PTO, paid any reason leave law, and increase the accrual rate from 1 hour for every 30 hours worked to 1 hour for every 15 hours worked. That would, as far as paid sick leave news goes, that would be a huge development. So we're keeping close watch on that. We could also see paid sick leave laws stacked on, or PTO laws, excuse me, stacked on top of paid sick leave laws. There's actually a proposal in New York City right now to do just that, to add a paid personal time law, 10 days that would go on top of the state's existing 56 hours of paid, or the city's existing 56 hours of paid sick leave. More litigation, more administrative enforcement. We spoke a few minutes ago about that activity and how it's ratcheted up over the last several years. more of that coming as these laws come online and gain more traction and familiarity and have been embedded in the legislation for many years. And then federal activity. What will happen? Will it be something that preempts? Will there be any federal activity? Will it preempt existing state and local laws, or just add another layer of the patchwork? There was a proposal earlier this year that gained a little bit of media attention that mirrors in a lot of ways the federal contractor paid sick leave law, but would not, as it currently is drafted, remedy this patchwork. So that's where we're looking. Plenty of more fun, plenty of more webinars for you all in the coming months. Next slide, please. And one more. So to help simplify, or at least help manage and navigate this space and the complexities that you've heard from all of our speakers today, we have a premium paid sick leave survey that breaks down each of these topics. You can reach out to paidleave@seyfarth.com for more information. You can also sign up for our paid leave mailing list as we publish articles and blog posts on these topics. You'll get them, so when we learn about something, you'll learn about something. Next slide, please. We also have this webinar series. We'll keep at it with parts 12 coming later this year and then into 2024 with additional parts as the activity continues and the volatility continues. And we also have a dedicated leave of absence and accommodations podcast called Take It or Leave It that has a lot of great information and content for you there from a number of internal and external subject matter leave experts. Final slide. We have our California specific resources for you here, including our 2023 CalPEX ebook that came out a couple of months ago. So again, if you need help navigating this space, there are wonderful Seyfarth team resources available for you. The final slide. We will turn to questions, I think, for just a couple of minutes. We did see some folks send in some questions, so we want to address that. And please, folks have questions beyond today, don't hesitate to reach out to us. Our contact information will be provided in the slide deck, which will be sent around to folks. But let's tackle just a couple of these questions for anyone who's able to hang on here. So for starters, there was a question, Chelsea, I'm going to punt this one to you. I think a quick clarification. With California and front-loading paid sick leave, is there a new requirement starting next year to front-load 80 hours in order to get rid of carryover and accrual?
No, the new requirement would be 40 hours if you're, and this is assuming you're only subject to the state law, not subject to the local ordinances. But if you're just subject to the state law, the state requires now it'd be 40 hours of front loading to get rid of the carryover.
Yep, perfect. Thank you. Let's tackle another one here. So I saw this one come in during the unlimited leave discussion, and maybe Tracy, I'll get this one over to you. So just in terms of maybe highlighting some problems that employers who sort of have unlimited leave and don't kind of distinguish between sick and vacation, can you maybe reiterate a couple of what some of those challenges look like for companies and why we try to steer them away from that setup?
Sure, because if you're using such a policy, it means I might be able to take unlimited paid time off and have it substituted for FMLA without applying for STD, without applying for paid family leave, without doing any of those sorts of things, because I would argue it's available under the unlimited PTO policy. It may mean I then determine that I should take off unlimited time for bereavement leave or other reasons. Think of other states' small necessities leave laws, such as time off for domestic violence or sexual abuse, time off for blood donation, time off for organ donation, right? All of those things can be factored in. And if you are using the unlimited PTO as a substitution, it also means that those other paid leave benefits are still available because they haven't used them. And so now is someone going to come and try and stack their time and say, okay, well, I've exhausted my FMLA, I've exhausted my quote unquote unlimited PTO. Now I'm going to apply for STD and I'm going to keep getting paid for all of this time. So there's a number of worst case scenarios that I know oftentimes people want to say, oh, that would never happen. Trust me, we are not that creative. We do not come up with all of this on our own. It's because we've seen it happen or a client has told us it has happened. So we give you these examples because they are in fact reality, and the possible consequences that you could see.
Yeah, no, absolutely, Tracy. Thank you for that. I'm gonna turn to the next question here. We'll just do one or two more quickly. So we saw a question come in terms of when we're addressing the various state laws, can we touch upon sort of the impact of employee thresholds within the particular state and how the laws kind of tackle that topic? Marlon, can you maybe give a few high-level thoughts on that one for us? Oh, Marlon, I think you might be on mute. Oh, that's all right. I'm not hearing Marlon, so I'll tackle that topic. So super quick, the way the paid sick leave laws are set up here is, frankly, a lot of them don't differentiate between having just one person in the jurisdiction or having 500 or 1,000 people in the jurisdiction. And to the extent they do have a standard regarding employee headcount threshold, it's very often going to be ambiguous. Now, there are a few locations like Connecticut, like Nevada or Maine that do say, look at the number of workers that you have in the particular jurisdiction for determining whether you're a covered employer or for determining whether you have to offer a lower amount of annual accrual and usage or a higher amount of accrual and usage. But very often the laws will either say nothing in terms of determining, or they'll say, the employer, you need to look at your nationwide headcount data. So, and that is the majority of the laws fall into that latter category.
Right. So stay tuned for more details on further laws as they come into fruition. And Josh will be back with many, 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 many more webinars and other great speakers with him. Maybe Chelsea and Marlon will appear again. I told Josh, if I have to talk about this topic in 10 years, it better be because I'm retired. So thank you all for joining.
Yep. Thank you, everyone.
Bye.